Hello friends, welcome to my YouTube channel Advocate Amit Kumar Gupta. Today we are going to discuss a very important case on section 143 subsection 2 notice in the case of AMBA Construction Company versus Assistant Commissioner of Income Tax. This case has been reported in 100 ITR Tribunal at page number 295 and the matter has been decided by Delhi ITAT. The date of the judgment is 28th April 2022. In this case, the assessee was into the business of construction business. The assessment of the assessee was completed under section 143 subsection 3. Before that, the notice under section 143 subsection 2 was sent to the assessee through the speed post, but this notice was not served on the assessee and it came back to the department with the remark that no such address is available. So practically, this notice was not received by the assessee, or in other words, this notice was not served on the assessee in terms of section 27 of the General Clauses Act and read with section 143 subsection 2 of the Income Tax Act. Both the sections says that the assessee should have come to the knowledge of the notice. But when the notice is being unserved with the remark that no such address exists, it means that the notice is not being served on the assessee. It may be because of wrong address written by the assessing officer. It may be because of wrong address available into the assessing officer records. So whatever may be the reason, but the notice is not being served on the assessee. So if the notice is not being served on the assessee within the prescribed time, and even if the notice is being served after the prescribed time, or the assessee comes to the knowledge of the notice after the prescribed time, even then the assessment proceedings cannot be proceeded against the assessee, because the rule of law is that the notice under section 143 subsection 2 must be served on the assessee before the prescribed period. But this case is applicable on those cases where the assessment has been completed and the notices were being sent through the speed post, but nowadays the notices are being sent to the assessee through SMS, by uploading on the income tax portal, or by sending the email. As far as the SMS is concerned, it is being delivered to the assessee at the same time, or sometimes it may happen the message is sent but the message is received by the assessee after the prescribed time. So if we go by very technical terms, in that case it will not be deemed as service of the notice if the notice is being through SMS beyond the prescribed date. And if we come to the notice through the email, if the email does not hit into the inbox of the assessee before the prescribed period, it cannot be deemed as service of the notice. But the question comes that when the notice is being uploaded on the income tax portal before the due date, whether it will be deemed as a service of notice or not. It is not practically possible for the assessee that assessee every day opens his portal and came to know that whether any notice is being served on me or not. So in some cases the court has come down with the indication that if the login portal of the assessee is being logged in, then it will be deemed as that the assessee has come to the knowledge of the notice. But practically it is very difficult to convince that the assessee has not logged into the system, because these facts can be examined only at the level of the appellate authorities, and that too at the ITAT level or the High Court level. And these are very minute things, because the department may not give this information of the logs when the assessee has logged in into the portal, because these details cannot be easily fetched from the department. So if we go by the present day scenario, we cannot get very much benefit by these technical grounds, because the notice is being sent through the email. It is the responsibility of the assessee to provide the correct email ID. The assessee should be vigilant. The professionals of the assessee should be vigilant. But when the scene was there, when the notices were sent through speed post, in those cases we have to see that whether the notice was being properly served before the prescribed date. And if the notice is not served before the prescribed date, then the whole assessments can be annulled. At the end of this video, once again I am repeating the name of the case. The name of the case is AMBA Construction Company versus Assistant Commissioner of Income Tax. Thank you, friends.